Good afternoon and welcome, everyone. Thank you so much for logging on to join us today. We are offering a Fair Housing 201 for rental professionals class with big thanks to our generous support received from the Michigan State Housing Development Authority, or MISTA. My name is Liz Keegan. I'm the Director of Education and Outreach at the Fair Housing Center. I'll be co-presenting today with Brianna Miranda, another Education and Outreach Coordinator member. And behind the scenes, we have Lindsay Owens working very hard to help more than hopefully 400 folks log on. So we continue to see folks joining us. So welcome. Please do scroll up to the top of the chat box and take a look at some housekeeping. It's really exciting to see folks signing in from all over the state of Michigan, and I know we have a few folks even from outside of Michigan. We're very thankful for MISTA enabling us to offer this series. This is the second class in a three-part series, and we will be offering a 301 as well. And many of you, I think, were with us for the 101 that we did in December last year already. So thank you for coming and joining us today. You should have received an email with some handouts. If you have not, please let us know, and we can forward those materials to you. A little bit of housekeeping. We will share a link towards the end of the class today that will ask each individual to complete. So even if you're watching as a group or there's a couple of you, you each individually need to fully complete this evaluation at the SurveyMonkey link by the end of the day tomorrow to record your attendance and to get information from you about where we should send your certificate for completing the training. It will take us time with over 400 folks registered to attend to get those out to you. So please be patient with us and give us about a month to get those certificates out. You are all muted and your cameras are off. You can use the chat to connect with staff if you need assistance. We ask that you use the Q&A to send clarifying questions about the content as we go through the afternoon together. We'll try to save some time at the end for detailed questions about the content. If you have a specific situation with a lot of facts and details to share, we do ask that you just email that to us with a full house, so to speak, in our online webinar. We want to make sure we can give good attention to questions that we can answer quickly. And so if it's kind of a specific situation with a lot of details, please do email those to us and we will get back to you. The emails are on your slides that you should have received in your handouts. So once again, we will be taking attendance through the evaluation and survey link that we'll share at the end of the class today. But again, it's so exciting to see all the different communities and different folks logging on from all over. We are really excited to be able to offer this opportunity. If you haven't received the handouts, please put your email in the chat and we will follow up with you. Just making sure I'm getting all of my housekeeping out of the way. And again, we'll share that link towards the end of the class. Some of you might have it open in your browser, but we ask that you use the link in the chat that we'll share before 3:30 when we wrap up today. I know what I was thinking of. We will also take a 5-minute break about halfway through. So it's going to be a short break, but it'll give you a chance to stretch your legs and maybe get a little more water, tea, coffee, hot cocoa, something to keep you warm. So, all right, I think we will go ahead and get started. I'll make one last plug because our numbers are ticking up. We will be taking attendance using an evaluation through a SurveyMonkey link that we will share at the end of the class. And please put your email in the chat if you need the handouts. Thank you so much. As I mentioned, we have a team of 3 in our Fair Housing Center Education and Outreach department. Brianna will be joining me, Bree speaking today, and Lindsay is keeping us running on Zoom. Having some technical difficulties with some of the Zoom changes that they keep making on us, but here's how you can contact us directly. And I highly encourage you to visit our website, FHCWM.org. The handouts with the PowerPoint slides should all have accessible links for you. So anything linked in blue, you should be able to click on it to either go to the site or maybe even send the email if your computer is set up to do that. So we gave you a lot of information to take away with you, but a lot of it is through the links in this PowerPoint, which is one of your handouts. Okay, so what are we going to talk about? Well, we have lots to share with you, so we'll be moving quickly. We'll be asking some poll questions throughout the training today. We'll start with kind of a quick overview of fair housing laws, but we have a lot of new protections and HUD guidance to talk about. We'll talk about what's happening in terms of housing discrimination cases at the national and local level. We'll take a deep look at the gender protections, including equal access rules and the Violence Against Women Act, and then some specific topics looking at how the laws apply in advertising and affirmative fair housing marketing, occupancy issues, applications and eligibility evaluations, disability status protections, of course, including assistance animals and how to process accommodations and modifications. Once again, we will be offering a 301 class next month that will go even further with more topics. So thank you all for joining us, and I encourage you to keep an eye out for that link that we'll again share at the end of the training for both an evaluation and other training opportunities. Lots of links and resources. So make sure you get that handout. I see some requests in the chat that our team is working on. Our first poll question is a two-parter. Going to launch it here. True or false? Our first question, under fair housing law, a person can be held liable or responsible for a violation even if they did not intend to violate the law. True or false? Number two, fair housing laws don't protect housing providers or their employees. True or false? What do you think? Give you time to make your selections and submit your answers. And yes, we do have a link to the 101 class that was held in December that is on our website, on our training page. So that is something that MISHDA has enabled us to do, not only to offer these trainings, but also to record them and share them out. So that's really exciting. So nice to see some familiar names, new names, communities from across the state. And as I mentioned, I know we have people from, oh, the poll disappeared. Sorry about that. I'm seeing that for a lot of you. Some of you are answering it. Gosh, I mentioned Zoom technical difficulties, and here we are. So if you can answer it, great. If not, don't worry about it. We don't use it for any sort of testing or completion or grading. It's really just more of an interactive activity. We'll let those of you fill it out who can, and then share the answers here in a moment. Oh, it's back. Okay. This is just like choose your own adventure. What's happening? Um, okay, thanks, Bree. We can blame that on me. It's typically my user error. I will try to share the results. And if you don't see them, Bree, feel free to maybe step in. But I'm going to go ahead and close the poll in about 10 more seconds. All right, and hopefully you are seeing results. Are they showing? Thumbs up or down? Yes? Okay, great. So under fair housing laws, a person can be held liable for a violation even if they didn't intend to or mean to violate the law. And that is true. 95% of you said yes, and that is correct. That is how fair housing enforcement processes are set up here. We are going to be talking about Michigan processes, Michigan law, and specifically housing funded under HUD or MISHDA today. So I just want to make that disclaimer available to you. And also, we are not attorneys, so none of this can be considered legal advice because we are not attorneys. So hopefully that makes sense. But yes, if somebody violated the law and didn't mean to, we understand and again appreciate your time here to learn what the law is, but it's still considered a violation if the laws were broken. Number two, fair housing laws don't protect housing providers or their employees. And that is false. The fair housing laws do provide protections for housing providers and their employees, and we'll share some examples. But for one off the top of my head is that any employee of a property management group cannot be required to discriminate as part of their job, for example. Okay, thanks for playing along with those. A little bit about us. We are a private nonprofit. We focus on preventing illegal housing discrimination whenever we can. We look to uphold housing choice and the creation and sustainability of inclusive communities. We do this through both our education and work, but also through advocacy and helping people file complaints with enforcement agencies. That includes HUD or the Michigan Department of Civil Rights or MDCR. People also have the right to file in the federal or state courts or work with local governments if they do have fair housing ordinances. So we kind of operate in that middle space. As I said, we are a nonprofit. We cannot provide legal advice because we do not have attorneys on staff. So all information provided is for educational purposes only. And we're all very passionate about fair housing because we really believe that where you live impacts how you live. So being able to choose freely in spite of the conditions of the housing market is really important for people to have good quality of life and have access to the things that they've identified are important for them. We have other fellow fair housing centers across the state of Michigan. There's also a National Fair Housing Alliance group that can help you find other fair housing agencies. If you need that help, if you're outside of Michigan, feel free to contact us, but you can look at the National Fair Housing Alliance for assistance. We are the West Michigan Fair Housing Center, the last bullet here, but we have neighbors to the south in Southwest Michigan, the Kalamazoo area, another fair housing center out of Southeast and Mid-Michigan, so kind of Ann Arbor, Ypsilanti, and then a fair housing center of metropolitan Detroit. And we kind of share the service area of Michigan this way. We are the teal green service area, so that's about 38 counties, but we do provide a lot of education, especially to the counties in orange and dark blue. So we're happy to be your first stop, and we will be sure to connect you with your local fair housing center because they're going to know more about laws at the local level, the conditions of the market, things like that. Fair housing is all about upholding that choice, as I mentioned. It's based on protected classes, so we'll always be focusing on who is protected. There's laws that exist at the federal, state, and local level, as many of you know. So we're always kind of looking at what protections apply based on the geography or where the housing is. So you'll always hear us talking about, who is the protected class and where is the housing, so we can kind of determine what laws apply. We also will ask, how is your property funded? If you have HUD funding or are financed under MSHDA programs, we'll be talking about those specific obligations that come with accepting federal and state money. That triggers application of more guidance that we'll be looking at more deeply today. Fair housing laws prohibit discrimination really across the housing transaction process. It includes rentals, sales, lending, homeowners insurance and other insurance policies, appraisals, zoning and land use decisions. So the fair housing laws are far-reaching. And I do want to say, if you are managing housing, you own housing, you're a landlord, you're going to want to default to fair housing laws first. I was just talking with somebody who had questions and they were using the Americans with Disabilities Act and trying to find information about housing. And the Americans with Disabilities Act, or ADA, really doesn't cover within a housing unit or within a dwelling. It may cover a community room or an apartment sales office, but really fair housing is the place where you're going to want to start in managing and offering housing. The protected class list is growing and will continue to grow here in Michigan. Federal protections include race, skin color, national origin, meaning where you're from or your ethnicity or ancestry, gender, including sexual orientation and gender identity, religion, physical or mental disability, and familial status, meaning families with children. So these are protections that exist across the entire country under federal fair housing laws. Housing with HUD funds are subject to the Equal Access Rule, which we'll look at in more detail shortly. That expands protections to prohibit discrimination based on whether or not somebody is married, meaning their marital status, and also sexual orientation and gender identity. Then here in the state of Michigan, we also have marital status protections. Sexual orientation and gender identity or expression are protected as of February of last year. So we're coming up on the 1-year anniversary of that expansion, and age protections have been in place. And then locally, we had such a great turnout with so many hundreds of you logging into this class. You'll have to do a little bit of homework if you don't know what your local fair housing laws are. And I have some resources that we'll look at in a minute. Here in Michigan, again, the state laws expanded in 2023 to add a definition of race, which prohibits discrimination on the basis of race, inclusive of hair texture and protective hairstyles like braids, locks, and twists. This is the Crown Act, or Creating a Respectful and Open World for Natural Hair Act that went into effect immediately. This law also gave us kind of forecasting protections for sexual orientation and gender identity, which are now officially in place. Other really big news, I mean, literally as of this week, and one of your handouts is 5 bills that went through the Michigan House and Senate that were all approved. The governor has now signed all 5 bills, adding source of income protections across the state of Michigan. There are bills that amend, all 5 bills are tie-barred together, so they're a package, and they amend our state civil rights law, the Elliott Larson civil rights law. We call that ELCRA for short, and our Michigan Landlord Tenant Act. They go into effect on April 2nd of 2025. So we have a little bit of time here before the source of income protections go online legally. So we're going to just kind of take a look at what these protections will be once they start this April. We have a definition of what is meant by source of income. It includes benefits or subsidy programs, including housing assistance, housing choice vouchers, or HCVs, low-income housing, essentially. I've got that linked to that U.S. code there. Public assistance, veterans benefits, Social Security, supplemental security income, other retirement income, programs that have dollars associated for housing that are administered by any federal, state, local, or nonprofit entity. The source of income protections do not include either of the following: income that a prospective tenant cannot demonstrate is derived from sources and activities permitted by law and is provided on an ongoing basis. So it needs to be legal income that you can verify, and it needs to be ongoing income based on these bills. Another kind of caveat is that housing assistance that is not approved by an agency that's issuing that assistance, like a voucher, has to move within 30 days after the landlord provides all the information necessary as a condition of the agency's approval. They've got to move fairly quickly. So now they have that time limit there. It also includes that evidence that all repairs that would be required by the program or agency have been completed before somebody can move in. So these bills have been tweaked, and this is the final here. There's a lot of information on each slide, but I really wanted to just kind of take a look at items A through J. What is prohibited on the basis of source of income? So a person who's a landlord cannot do any of the following if it's based on somebody's source of income. Of a prospective tenant, an applicant, or a current tenant. You cannot deny or terminate a tenancy because of source of income. You can't make any distinction or discriminate, really change any of the pricing, terms, conditions, fees, or privileges for applicants or current tenants because of their source of income, change any of the furnishings of any of the facilities, or change any of the services that come with the rental, lease, or occupancy of the unit. So really that equal treatment is assured here. It's also important that providers do not deny or make housing unavailable if they otherwise qualify. If they meet any other eligibility requirements except for income, they should not be denied solely on the basis of source of income. It's discouraged or illegal to represent to prospective tenants that the unit is not available, whether it's for inspection, rental, or lease, when it is. This is a very basic tenet of fair housing laws. Representing housing is unavailable when it is based on a protected class is uniformly going to be a violation, and that is no exception here for source of income. And that includes, just omitting it, not telling people about it, or not letting folks see the unit because of their source of income would be violations as well. Making any, again, differences in price, conditions, fees, or privileges related to it on the basis of their income. Let me move. Things are moving around here and I'm not able to see there we go. If a person is a landlord that requires somebody to have a certain threshold level of income, it's a violation to exclude any source of income in the form of a rent voucher or subsidy. This doesn't include emergency rental assistance for that evaluation of total household income. And other violations, we're getting to the end of the list, attempting to discourage someone. That messaging is very important. You've heard us talk about how important it is to be welcoming to anybody seeking information on the housing opportunity. It's also a violation to publish or advertise any sort of notice or statement. You'll recognize some of that language that really prohibits or has a preference or limits or ties any requirements due to source of income protections here. And then these two elements, these final two that will look like, on the basis of the source of income, it would be a violation for someone really to pressure or coerce or help someone commit a violation of this law. So again, here's a protection for employees where you can't be required or coerced or forced to violate this law as a condition of your employment. And kind of on the flip side, anybody who is protected and uses their rights under this law should not experience coercion, intimidation, threats, or interference with their ability to use and, exercise their rights under this new law, again, that will go into effect April 2nd of 2025.
Uh,
Yep, go ahead.
Somebody had a question. Did you discuss the minimum income requirements that a landlord might have? They said it was 2 slides ago.
We discussed it 2 slides ago. Okay, I'm not sure when that question came in, so I'm going to try to find it. But essentially, having your minimum income requirements needs to include any legal and verifiable source of income towards that total. So I'm hoping that's what the question is asking.
Thank you, Liz.
Yep. Okay, and then they're just kind of explaining under tenant landlord law. A lot of these languages is mirrored between tenant landlord bills and the Elliott Larson bills, and you have all five in one PDF document. So you've got those bills, and you've also got the Elliott Larson kind of proposed amended document that will go into effect in April as well. Person meaning who's exempted here? Sorry, this specific sections do not apply if somebody has fewer than 5 rental units, looking at all related entities to that person. So if there's a LLC, any corporation, you would be covered looking at any Michigan properties as a total number of units as to whether you would be exempt to this application of this law or not. So that's the one exemption. And then here are the resources I mentioned for checking with your local fair housing center. Checking with your local government is another option. There's also code libraries. These are Michigan-based links, but they're national code libraries that you can use. I took a look at some of the registrations that we got. So I want to call out that Ann Arbor, Detroit, Grand Rapids, Holland, Jackson, Kalamazoo, Kentwood, Lansing, Traverse City, Wyoming, East Grand Rapids, all have fair housing laws at the local level. So that's an important piece to get familiar with if you haven't already. We really recommend that you get information on all of the protected classes based on where you're operating and take a look at using that as kind of a tool to help you evaluate whether something is a fair housing issue or not. Okay, got another poll question. Hopefully this one will behave. We'll give maybe another 30 seconds here. Okay, let's go ahead and end and share. Looking for, there should be two questions here. Looking for what are the top three protected classes reporting that they are experiencing housing discrimination based on which protected classes? Kind of our first question. And the top three reported bases across the country in order are disability, which 74% of you got. Second place is race, which 93% of you selected. And the last one, the third place is gender, which 42% of you selected. So you've got the three of them, absolutely. The fourth group is national origin as well. And just a trick question, since this is an advanced level class, a bonus question, I suppose I should say, which are not protected classes at the federal level? We looked at these a couple moments ago, and age and marital status protections. So quite a few of you got those right. Age and marital status protections are here in Michigan as part of Michigan law, but not federal law. So great job. That is not easy. Um, Also want to make you aware of HUD guidance. There's two new documents that were released at the end of April, 2024. I have to get used to saying last year. We want to make sure you're aware of them, and this is something we will discuss in more detail in our 301 trainings. We'll have a 301 training next month. We will also offer a second series of 101, 201, and 301 classes, I think beginning in summer. So all of that's available on our website. But we just want to make you aware these links will take you to these pieces of guidance. It's really looking at the impact on housing through the use of artificial intelligence, digital advertising, online platforms, kind of how we do business these days. There are two separate documents. One focuses on advertising and one focuses on screening of applicants for rental housing specifically. So very quickly, the advertising guidance is looking at ads, for example, targeting Black neighborhoods that have language that says no criminal records and good credit only included in those ads targeted to those neighborhoods based on race, while ads targeted to white neighborhoods would not have that type of language. Another example of a violation would be mortgage ads for men that has detailed information on current rates, but ads for women saying getting a mortgage is easy. Clearly not equal treatment there. So those would be violations. Guidance focusing on screening of applicants. Again, we'll look at this in more detail, but just want to highlight this document talks about how tenant screening services offered by third-party companies and also just how we screen, regardless of what technology we use, can violate fair housing laws. It includes fair housing issues that are common and suggests ways to avoid discriminatory screening not only for screening companies, but for housing providers. So even if you're not using a screening software program or company, you may want to take a good look at this because there's some really good guidance throughout. It's really well written. It's pretty reader friendly. It's not as technical as some guidance that we've seen in the past. It gives guiding principles for non-discriminatory screenings. And a lot of these are things that you've heard us talk about in the past. And we will again focus on these and also criminal background screening in our 301 level class. But, having screening criteria in place that's relevant to the housing and selecting good tenants, using accurate records, following your policies. You've heard us talk about being consistent a lot. You want to be transparent with applicants, allow people the opportunity to challenge negative information or, faulty information. We know there's a lot of inaccurate information available out there. And then if you are working with a third-party screening company, then you want to have some testing and models in place to look at fair housing compliance. Also in the screening guidance, they've kind of outlined several areas that they're looking at as additional considerations. There are some unjustified discriminatory effects for some screening standards that impact some of our protected classes, such as race, color, national origin, people with disabilities, women, families with children, survivors of domestic violence. These are protected groups hit harder by credit history screening standards, eviction history screening standards, and criminal background screening. So again, this is something we'll revisit, but we wanted to make sure you were aware of the guidance because it's been in place now for, come up on a year in April. Trending, what's happening in terms of fair housing complaints, 83% of complaints from data collected in 2023 across the country are violations alleged in the rental process. So again, we want to thank you for taking time to log on and join us today and look at fair housing best practices and what's happening in fair housing. So rental transactions make up a large percentage of where housing discrimination is alleged to occur. We also see it in sales, lending, insurance, harassment, appraisal, advertising. HOA and condo groups also do see some cases, as we've seen here in our service area in West Michigan. This is our data for 2023. We're still finalizing our 2024 cases and numbers. We've mirrored what we saw a little bit at the national level with disability cases leading our caseload, followed by allegations of discrimination based on race or color. And then families with children is our third place. And then within our 4 cities that do currently have source of income protections, Kentwood, Wyoming, Grand Rapids, and Holland, we had 4 cases, followed very closely by national origin discrimination and gender. Some of that which included harassment, which we did talk about in our 101 class. Again, our caseload is more than half alleged discrimination during the rental process. We also had a third of our cases related to failures to accommodate people with disabilities, and Bree will be talking about that in the second half of our time together today, followed by some sales discrimination, and we have seen an uptick in harassment, which is why we've really been including that in a lot of our trainings that some of you probably have seen. Okay, gender-based protections. I did see a question about an executive order. We are subject to HUD's warden memo, which has not been rescinded at this point. So things are changing day by day. We'll do our best to push information out. We're kind of relying on what we understand is in place and is being utilized as we go. Day by day, and then maybe week by week. However, these protections do exist under Elliott Larson Civil Rights Act here in Michigan. It was amended last year for sexual orientation, gender identity, and expression protections, and that is in place here across the state of Michigan. So we've got the 3 protections and the legal definitions here as they were included under law: gender identity or expression, meaning having or being perceived as having a gender-related self-identity or expression, whether or not it's associated with the individual's assigned sex at birth. Sexual orientation means having an orientation for heterosexuality, homosexuality, or bisexuality, or having a history of such an orientation, or being identified as such. So these are the state legal definitions of these current protections in Michigan. Those of you with HUD funding are subject to the equal access rule. Even if you don't have HUD funding, we want you to be aware of the guidance available to people who are subject to these rules. It's helpful to utilize as a guide for proactive compliance, especially now that we do have sexual orientation and gender identity and expression protections here in Michigan. The equal access rules have been in place since 2012, so there's a lot of resources. And again, it's all linked throughout here. So I encourage you, you're either subject to it or you can learn from what HUD is requiring of its own programs at this time. It's 3 separate rules that really expand protections in HUD housing and HUD programs to encourage access regardless of somebody's actual or perceived sexual orientation, gender identity, or marital status, which we also have protected here in Michigan. So you're kind of seeing those layers of protections now. Housing providers that receive HUD funding or, again, have housing subject to maybe a HUD-insured mortgage, lenders that use dollars all have to comply with the rule. It's not a law. It's not an amendment to the Fair Housing Act. It doesn't create additional protected classes, but it's applicable to HUD programs and housing. It expands really the definition of family in most of HUD's programs and includes definitions for sexual orientation and gender identity. A takeaway is when projects that are funded with these dollars serve any families with children, you must serve all families with children based on any different type of composition for the family: single dad, single mom, same-sex couples, opposite-sex couples, multi-generational families, non-romantic groups who present for services as a family, for example. The first equal access rule was issued in 2012, and again, it really expands that composition of the family, adults and children, or just adults. This is a basis that HUD programs cannot use to discriminate. It prohibits discrimination based on age and disability, which are also further protected, marital status, and expands to sexual orientation or gender identity. These are examples of some of the HUD-assisted or HUD-insured programs. For example, those of you with Section 8 or Housing Choice Vouchers, HCV, public housing agencies, PHAs, housing commissions, supportive housing programs specifically for the elderly and people with a disability, homeless-focused COC and McKinney-Vento programs. Cities often, a few cities across the state have CDBG grants or Community Development Block Grants that come with this obligation, Housing for Persons with AIDS or HAPA, Federal Housing Administration insured loans, etc. So this is part of the homework you need to do to make sure you're familiar with how you're funded so that you know which regulations apply. That was not a complete list. There were others. The second rule, equal access rule, was issued in 2016. It expanded on the 2012 statute and addresses how transgender and gender nonconforming individuals should be accommodated in temporary emergency shelters or similar HUD-funded programs. So providers that do operate single-sex projects using funds from HUD's community planning and development departments are required to make sure that all individuals, regardless of transgender or how they were assigned birth at sex, have access to programs, benefits, and services that match or are in accordance with their gender identity without subjecting them to intrusive questions or asking for documentation. So again, this is HUD's CPD programs, which could be continuum of care, homeless focused funded agencies that provide dollars through emergency solutions grants, HOPWA, Shelter Plus Care, supportive housing programs, other HUD assisted programs. It looks at admissions, occupancy, and operating policies and procedures, applies broadly. So recipients, subrecipients, owners, operators, managers, and providers, including maybe volunteers that might work at a shelter or a program that is gendered, for example, or contracted workers. The third rule applies to HUD's Native American and Native Hawaiian programs, and again is focusing on expanding those protections regardless of sexual orientation or gender identity. So this is the third part of this three-part rule. So just some best practices, again, kind of referring to whether you're subject to this or what you can take away from it, we'll review. And there's a lot of information here, so I really encourage you to check out the links. I apologize, my Misha logo layered over my source link at the bottom, but you can still see the blue there. Lots of good information available online. So educating staff, volunteers, residents about respect, equal treatment, having policies in place to ensure that, talking to all residents, especially if there's shared spaces, to help everybody treat each other with respect. Staff need to model respectful behavior and use appropriate language. You can have signage about non-discrimination policies. You can provide affirming resource packets, all ideas to create that kind of accessible, welcoming space. You may want to connect with resources in the community, supportive landlords. You want to look at all your forms, policies, and procedures to make sure they're kind of kept up to date. This is a good idea as we do see changing protections in Michigan and maybe at the federal level. You want to make sure that all of your documents are up to date as best as possible. We're doing the same thing with all of our education and materials. Think about multiple ways you can address and resolve impermissible conduct, incidences between residents. Take violence against residents, especially LGBTQIA plus residents, very seriously. So that means documenting any violations, responding. I mentioned we had an uptick in harassment. This is something that would also, want to be something you document, enforce your non-discrimination rules, enforce your leases or policies on behavior. You want to investigate any incidences or allegations of violence or harassment, again, especially if there's shared spaces, and make sure people are safe and the rules are being followed. In shared spaces like shelters, you want to increase privacy. There's different ideas here about using temporary permanent curtains, looking at locks, doors, or partitions in spaces, making single-use facilities all gender, meaning anyone can use them. If they are single-use, increasing privacy through maybe staggering times for people who could use or access shared bathrooms, things like that. It's very important not to ignore any harassment, and this is any type of harassment, but specifically here under equal access rule, that would include verbal and sexual harassment against LGBTQIA plus clients. These incidents should not be ignored ever. People should not be forced to appear as their sex assigned at birth or suggest that they should do so to fit in or for their safety. Keep an eye out for any victim blaming, people being punished or excluded, abused or harassed. And again, really promote that education about what you are responsible for based on what applies to you and your organization, and do your best to make sure individuals are comfortable with each other. It's really important to watch assumptions. So that's why some of this information they've got is really helpful. And again, there's a HUD guide that's linked here on a couple pages that's really helpful. Some clients may not identify as either male or female. This is a kind of a moving topic. There's been new guidance released. So we're going to keep an eye on that. We'll be pushing out information as soon as anything changes. So we're kind of operating on existing standards. So while it's in play, these are the resources that we would recommend you utilize. So if you are in a situation where you are running some sort of shelter or gendered housing, you can look to these steps in terms of trying to be accommodating. Programs really should have, if they are subject to the equal access rule, policies in place, procedures in place to make sure the rule is being implemented. It's always a good idea to have anti-harassment language specific under this rule that would include transgender and non-gender conforming in the list of groups who might be vulnerable or protected. Have a formal grievance process. Also a good idea as a general best practice to make sure it's available to folks. People can find it, can use it to help manage and resolve violations. Include confidentiality practices that keep clients' transgender status confidential if you're providing services to residents in conjunction with their housing. Some ideas on equal access rule and implementation for the atmosphere. You want to watch making assumptions based on someone's voice, refrain from using sir or ma'am, have a gender neutral dress code if there is any sort of dress code with the housing. Make sure, again, appropriate inclusive language is used across all communications, publications, trainings, handbooks, etc. Intervene and correct behavior if you witness anything happening in a disrespectful way. Have visible materials that communicate that all are welcome. Use clients' given names and pronouns in all verbal and written communications, including speaking with others in all reports and documents. This is just a sample. There's many out there. And again, I would recommend checking the HUD equal access rule guidebooks. Name and pronoun use, practice using them, practice using your own, use chosen names with clients. If feasible, given state laws, learn about the process to update names. Make sure you will let people know that you can assist with that if you are covered by the EAR. Use last names in calling clients from waiting areas. If you make a mistake, simply apologize and move on. Placement and accommodation should be made in accordance with their gender identity. Gender appropriate bathrooms and bedroom facilities, again, for shared areas, shelters, things like that. Make sure policies aren't isolating or segregating clients within the project unless a specific privacy request is made. Again, see page 17 of that HUD guide for specific strategies that can be used. Clients with special health concerns, trauma histories, or other needs may make reasonable requests for accommodations. So they may be made for any individual transgender or non-transgender who's expressed privacy needs and should be kind of made according to what they do need and what the ability of the agency is to actually do on the ground. You cannot require a transgender or gender non-conforming client to use alternative facilities, especially if this is kind of accommodating someone else's discomfort. Sometimes shelter clients do express discomfort regarding shared spaces, and that's not a reason to deny access to or equal treatment to the transgender person. Working with clients expressing discomfort to foster understanding of gender identity subject to this rule is important to create that environment that's respecting and valuing everyone. Examples from HUD about violations would be maybe a property manager overseeing an apartment with HUD funding refusing to rent to an apartment pardon me, refusing to rent to a prospective tenant who is transgender because of the tenant's nonconformity with gender stereotypes. That would be an allegation they held up as a violation. Another one is an underwriter for Federal Housing Administration FHA insured loans, reviewing an application from two men. If they assume they're a gay couple and deny the application on that basis, that would be a violation. Another one here for shelter specific, transgender woman seeking an overnight stay at a HUD-funded women's homeless shelter with shared dormitory style sleeping and shared bathrooms. If shelter staff refuse to address her as female, misgender her, and make other statements that would discredit her gender identity, that would be a violation. Also, if they refuse to shelter her in accordance with her gender identity, would be a violation as well. Some best practices. This is from SAGE, a great organization. They've since changed their name, but you can still find them through SAGE to take into account for best practices across the board, especially as we do have these protections here in Michigan. As of last year. So ensuring your non-discrimination policies are up to date, include all the current protected classes as we've talked about. Posting your policies written in plain language is always a good idea. HUD also wants to see their equal housing opportunity posters and logo displayed as well. Training staff on cultural competency that discusses LGBTQ plus, the use of appropriate terminology, maybe some of the history and culture. Making sure you're demonstrating dignity and respect by asking about gender pronouns the individual prefers, and include, again, all protected classes across all of your media and advertising, which we'll take a look at also today. Tons of resources here from HUD, so these links should all take you to different places, including the equal access rules themselves. But there's lots of trainings, lots of scenarios, lots of guidance available now here on some HUD pages. And then we will look at Violence Against Women Act. This was reauthorized in 2022. It's a federal law that does focus on people living in or applying for units that are subsidized by federal government dollars, and protects people who have experienced domestic violence, dating violence, sexual assault, or stalking. So we'll collectively refer to them as people who have VAWA violence abuse histories. It's focused on keeping them safe and reducing their likelihood of experiencing homelessness. And despite the name of the law, the protections again apply regardless of sex, sexual orientation, or gender identity. It's been reauthorized multiple times, most recently in 2022, which added some protections for survivors of domestic and dating violence, sexual assault, and stalking. It's specific, again, to covered HUD housing programs and certain other federal housing and homeless assistance programs. It allows HUD to enforce the law by the same processes that are in place to enforce the Federal Fair Housing Act. So kind of streamlining things a little bit there. This includes a right to report this directly to HUD to investigate the allegations. People who have experienced foul violence or abuse cannot be denied admission or federal rental assistance just because they are or have been a victim or are threatened. Cannot be evicted or lose that rental assistance, again, just because they are or have been a victim or have been threatened. Cannot be denied admission or rental assistance, evicted, or lose their subsidy for reasons related to the abuse, such as bad credit history and criminal history. So we'll get into that a little bit more. There's essentially kind of two areas to look at under VAWA housing protections. We've got links there to more resources. The first one is really broad. It's the right to report, which is the right for anyone to seek law enforcement or emergency assistance without being penalized, for example, by landlords or local law enforcement. People have the right to seek assistance. It applies to all people, whether they are or have been a survivor of VAWA violence abuse or live in federally subsidized housing. In addition, people can't be penalized due to criminal activity if they were the victim and were not at fault. You'll hear that several times. And then the second part of it is housing protections in those federally subsidized units. These are the rights that this population has when they're applying for living in shelter or rental housing units, again, funded by the federal government. You can find a full list of the rights at the HUD VAWA FAQ page, which is linked there. Here's some of the examples. There's protections from adverse rental decisions, so being denied admission or assistance, or being evicted or having the lease terminated due to experiencing VAWA violence or abuse. Allows for the option to stay in the unit, even if there has been criminal activity if directly related to VAWA violence and abuse. There's a right to request an emergency transfer to move to a new safe unit due to VAWA violence and abuse. There's protections from retaliation by the housing provider, including both landlords and service providers, for using these rights. VAWA covers programs extensively listed here. And again, if this is something you're not sure about, it's a good homework follow-up question. If you are a LIHTC housing, low-income housing tax credit, if you have home dollars, if you have emergency solutions grant dollars under uh, focusing on homelessness, voucher holders, project-based Section 8 housing, et cetera. And also housing commissions and public housing. If you are subject to this, you are required to honor these abuse protection orders, any other court orders that would be related, like a divorce decree, that address especially access to and control of the housing unit. Communities need to inform individuals of their rights under VAWA. That'll come up in a case I'll talk about here in a moment. It has to be included in lease agreements. Their rights should be included in lease agreements. In cases where both the victim and the perpetrator are parties to the lease, the law does permit the apartment complex or the community to bifurcate or split the lease in order to remove the perpetrator, evict the perpetrator, the person who conducted the violence, and allow the victim to remain housed. So kind of some subset also that covered housing providers have a lot of steps to follow and must provide 2 HUD-approved documents to applicants and tenants at certain specified times. This is really important. As I mentioned, it'll come up in a case. Emergency transfers, survivors of VAWA violence abuse can, under certain circumstances, ask for that transfer. If they need it to be safe, it's important that confidentiality is maintained so information doesn't get out. And then also covered housing providers have specific obligations to accept self-certification documentation about a person's status. Couple more points here. This is a group that should not be retaliated against. So covered housing providers can't retaliate, coerce, intimidate, or threaten somebody because they opposed any action or practice that's prohibited by VAWA. Again, we have some case examples here, or because they were a part of the process, they testified, assisted, etc. And again, right to report crime and emergencies from somebody's home, landlords, homeowners, tenants, residents, occupants, guests, etc. Applicants for housing have the right to seek law enforcement or emergency assistance on their own behalf or on behalf of another person in need of assistance. So that should not be a factor that they sought that assistance. A couple points here. LIHTC, that low-income housing tax credit and home projects must comply with VAWA. MSHA has extensive compliance resources on the top link there for you. VAWA protects housing choice voucher, HCV, and project-based voucher applicants, tenants, and participants from being denied assistance. So you want to make sure you are versed with that if you are affiliated or funded those ways. MSHA has a couple specific pages with VAWA focusing on housing choice vouchers. And there's also a notice document. It is a Word document, so you'll have to download this link when you click on it. But I found it was very helpful because it outlines the obligations under MSHA programming under VAWA. So we'll take a quick look at those if that's okay, Bree. I wasn't sure if you were popping on for, okay. So a couple areas here included in this notice: protections for applicants and participants. It's important that we acknowledge that VAWA violence and abuse is not a lease violation or cause to terminate a lease. The standard applies also, as I mentioned, to anything directly related to the VAWA violence and abuse with criminal activity. There's steps that we've talked a little bit about documentation, self-documentation, and how a housing provider needs to respond. So you can find more information there. It outlines moves that might be necessary. Somebody may move in violation of a lease if it's required to protect their safety. Here's the lease bifurcation, kind of a word we don't use very often, so I think of it as splitting the lease. The owner may choose to split that lease or remove a household member from a lease if that individual has engaged in criminal activity directly related to VAWA violence or abuse, and kind of gives outlines in how you must follow legal procedures for terminations of leases. That's all outlined on that document. And then finally, looking at evictions, VAWA generally prohibits evictions on the basis or as a direct result of an applicant or tenant experiencing or having a record of experiencing VAWA violence or abuse. It does not prohibit evictions for non-related violations. So if there's issues non-related to VAWA violence and abuse, they can be held accountable for those. And again, confidentiality requirements must be maintained. And then it ends with some documents or pardon me, it ends with some definitions to kind of explain some of the terminology and give a little more clarity on what is meant by, for example, economic abuse, technological abuse, what's meant by actual and imminent threat. Those types of terms are outlined there. These are a couple cases that I wanted to share very quickly. The HUD VAWA complaints, there was two settled under this reauthorization of 2022, one in Nevada and one in California. So we'll start with the Nevada case. This was a housing choice voucher holder that alleged that a public housing agency in Nevada, or a PHA in Nevada, and its housing specialist was also named. They allegedly violated her rights under VAWA when she requested to relocate mid-lease to move as an emergency transfer after being stalked by a former partner. The case alleged that the PHA demanded confusing and contradictory documentation, that it wasn't permitted to request under VAWA. So again, the benefit of kind of reviewing that documentation in that resource I just mentioned, they threatened to revoke her voucher, they denied her request to extend her voucher, and they stopped paying its portion of the rent while she was preparing to move to protect her safety. So multiple allegations made there. HUD investigated and found that the PHA's policies and procedures did not comply with VAWA, including policies for documenting someone's status as a VAWA survivor in general, and specifically when emergency transfer is requested. They did not have the required emergency transfer plan as well, so they did agree to a settlement, which includes getting new policies in place that do comply with VAWA, especially that emergency transfer plan that is required. That would enable survivors who qualify to move quickly without losing their assistance. They also needed to bring in outside experts to get VAWA training for staff, and a monetary settlement was included as well. So that was the Nevada case. And then out of California, a woman filed a complaint alleging a housing management company, which had home dollars and was a LIHTC property, and the property manager violated her rights under VAWA by denying her application due to a history of violations of the terms of previous rental agreements that were related. So her rental history was related to her status as a survivor of dating violence, and they used that, she alleges, to deny her application. The providers denied that she disclosed her status as a protected person, as a dating violence survivor. They did acknowledge that they failed to accompany the denial letter with any information about her rights, which we have established is required. You've got to have that information at certain places as required by law. And they didn't advise her about how she might appeal the denial. So they did settle, and it includes a monetary settlement. She's now at the top of two wait lists at two of their properties. They're revising their policies and procedures, getting a VAWA rights coordinator, and also having annual VAWA training. So some best practices, again, on how housing providers can assist victims of VAWA violence and abuse. Make sure properties are well lit, safe, and secure. Complete repairs, especially those that kind of can secure a unit, like broken windows, locks, doors, things like that, in a timely manner. That's a best practice, I imagine, across the board. Acknowledge any protection orders and assist with enforcement as necessary, excluding a violent person from the premises, I would imagine following your policies. Assist in pressing of criminal charges if needed, maintaining that confidentiality. Do not give out victims' contact information, addresses to anyone without a specific release from the tenant, and a core element of recognizing that VAWA violence and abuse is not a lease violation. Okay, so that was a lot for our first hour.
And
Bree, you want to dive in here for a moment before we go to break?
yeah, we had a few questions come in.
All right, great.
Um, there is a question about if someone has been housed coming out of a shelter because of DV, can they break a lease for any reason because they have been through DV in the past, or can they only break a lease because of DV currently going on in their home?
So I would definitely check out that MSHA resource in terms of whether they would be covered. My understanding is the history would if the incident that's causing the need for the lease to be broken is based on the history, that may be an element because it's pretty clear repeatedly that it's history of, has experienced, is a victim of VAWA violence and abuse. So I think we probably need a little bit more information, and I would look to those pieces too as a starting point.
And I know we've covered it in the past, but maybe not in this one just now. What if the VAWA victim continues to allow the abuser into their home?
Yeah, so I don't have any specific best practices. We can certainly look into that a little bit more, but that becomes certainly very challenging, and you would want to establish, that that is indeed actually happening. You always want to have documentation that you can point to that will help then kind of guide what happens next. It needs to be verified. So if it's kind of being rumored or, you hear that somebody's making that statement, it needs to be verified before any next steps, I think, would be taken. Would you add anything, Bree?
Yeah, I think I think it would depend on what the scenario and
Yeah, more,
yeah.
yeah. I mean, if they're still on the lease, if the lease hasn't been split, are there any protection orders in place? We kind of need a little bit more information. It is a very important question, and we certainly understand that this can happen, but just a lot more information might be necessary to determine. And I think that's the first step is really gathering that information and verifying accuracy, and maybe establishing, some kind of evidence or proof so that that can, kind of direct what happens
And
next.
I understand a lot of our training for folks spurs a lot of questions, a lot of what if questions. And
Yeah.
you may not have all the details right now because you're thinking about it, just like what if this happens? And
Yeah.
that's totally understandable.
Yep.
Um,
We
but
like that.
uh, but as the Fair Housing Center, when the circumstance comes up, then that's when you can call us and give us all the details. We can try to best answer the what if questions, but we need, all the
Yeah.
details to help. So
Yeah,
always.
the more information that can be provided to us, yeah, Bree, that's a great point. Uh, share details with us so that we can make appropriate assessments. And we'll probably first respond with more questions. And that's okay. That's what the dialogue that we want to have to be helpful to point folks in the right direction.
They did follow up. It's been verified what's next steps, not on the lease. For this specific situation, please definitely email us because we can't get into a lot of specifics
Mhm.
just due to time constraints. So feel free to reach out to us and we can provide.
Yeah, and please include the type of funding and the geography too. There are some local communities that also do have domestic violence status as protected classes, so that's helpful for us to know. Those are some of our, almost always going to ask you, how are you funded and where are you located? So that would be really helpful to have.
Um, the uh,
Oh, they're giving a few more details, yeah, which is helpful, but we probably can't address that right now.
yeah. What can we legally ask for as proof of violations from another property that are VAWA related? That's a good question.
What can we legally ask for? So, is this part of a reference history? What from another property? I think I need a little more clarity on that.
I was understanding it as proof of violations. Yeah, probably I would assume the violations, the least maybe least violations.
Of another property. Yeah. Oh, yeah. Oh, I see. Okay. Sorry, I'm with it now. Um, I would refer back to the MISHDA document that I think outlines a little bit more of that. And then if you're not finding it, let us know and we can kind of help look. I don't have specifics of what might be proof offhand. Yeah.
And then we did have some source of income protection or some source of income questions that I wasn't able to get to. Um, when source of income is placed into law, I understand we will need to include that. However, will landlords have additional work involved as paperwork and inspections of the rental units? And I'm not sure if we can fully answer that as we're not.
Yeah, we've requested information from the state of Michigan about, how this is going to be enforced and what are they looking at in terms of providing education on this. So this is all very new in terms of getting up and running on the ground. Um, but essentially, there is likely to be some paperwork and documentation, some inspections for most of the voucher-based programs, from how I understand it. If the approved rent of a voucher is lower than the rent, is it acceptable tonight to deny housing? Oh, I think that was a follow-up.
Yeah, somebody had asked a question, do we have to lower our rent to accept a voucher? So I wasn't sure, and I think that's what that person was
The
responding
follow-up. Yeah.
to. You do not have to lower your rent as a requirement. However, and so a few people have questions on this, the way it's calculated will be different on the threshold of income. So I'm thinking that was maybe where that question comes from.
Mhm.
Um, and for those folks, I did answer it in the Q&A, but you would we're still, as Liz mentioned, this is new, so we're still getting more information on this. But based on other source of income protections locally, we've understood that the landlord needs to calculate the tenant's portion of the rent. So if the rent is 500, the vouchers for 400. The tenant is responsible for 100, so that would be they are responsible for three times that 100 is our understanding. However, as Liz mentioned, as we get more information from the state, we will be able to provide more education on this.
Yeah, that's been a more equitable approach that I think some providers have undertaken, is really only utilizing the portion the tenant is responsible for as a way to help, you know, increase housing choice, really, for a lot of folks. Yeah. Great questions. This is all really new. So, as we continue to do more trainings throughout the year, we'll continue to kind of incorporate more information. We also send out like fair housing newsletters and bulletins. We'll share information on our website. So stick with us, and we'll push information out as quickly as we can get it. It does take a little bit of time. I think we're going to have to work with the state a little bit in terms of looking at maybe some best practices, and really learning what they think this is going to look like on the ground in Michigan, as they are the enforcement authority.
I think that is all our questions for the time that
Okay,
we have.
great. It's 2:05 by my clock. Let's take a 5-minute break and be back by 2:10, and we will dive into the second half of our training. Thank you all very much.
All right, welcome back, everyone. Thank you, Liz, for all the wonderful information shared before this break. And then I will start diving into some more here. First, we're going to start off with the application of the law. So, the thing to think about is the concept of difference in treatment and how that is considered when looking at fair housing laws. So everyone is required under fair housing that each person is treated equally. And the key is the consistency of the same type of quality of all persons. Just treating people equally across the board is the first step. Again, regardless of the different protected classes. It's important to train all your staff, the owners, and anyone else who is interacting with tenants and applicants. Fair housing training is just a really great way to do risk management. Um, and then additionally, do not volunteer inappropriate information about the neighborhood or make comments about any type of person that may be living in the neighborhood. Oftentimes people are asked, like, what does this neighborhood look like? And it's just really important to not answer those questions with a protected class in mind. Using statements like, there aren't many people like you here. Is not really a best practice. Don't really talk about the racial makeup of the community or if there's men or women in the community. Rather, you can just direct them to a neutral source. Usually, a census data could be like the way to do so. Just saying, oh, you can check out the census data for this community to figure out those type of questions. Do not make any assumptions about folks, both their financial qualifications, their rental history, their neighborhood preference. Be welcoming and encouraging. If you're not really sure how to answer a question or don't have an answer, you can take their information and pass that along to a staff person so they can follow up. You can just say, "Oh, I need to follow up with my coworkers. Let me get your information and follow up to you." That's a good way and something that we also do. If we're not really sure of a question, we always consult the other people on our team to make sure that we're giving the best information to folks. Always, we harp on this a lot. Describe your program, describe your housing amenities, describe your housing, but do not describe the people that live there. It's best to not inquire about a person's disability or perceived disability. And then also a way to communicate effectively, make sure that you have a list of auxiliary aids and services for people with disabilities, especially those with vision or hearing impairments. And along with that, make sure that all your staff is aware of what type of services and things are available in your company. Now moving on to advertising and marketing. We do have a poll here first. The first question, an advertisement stating that the property has grab bars in the bathroom and a ramp at the front door is an example of illegal steering. True or false? The second question there is this ad be permitted. Would this ad be permitted? Sorry. Two-bedroom apartment, washer, a dryer, no smoking, pets okay, not for elderly or infirm, $12,000 a month, first and last plus $600 deposit. True or false? Would that ad, that language be allowed? I'll give a minute maybe here. See how fast you all are responding. All right. Looks like people are slowing down. I'll give another 10, 15 seconds here. Let me get your answers in. Okay. So sharing the results here for the first one. Uh, 68% of you were correct. That would not be an example of illegal steering. It is important to show that a property has these amenities for people with disabilities. Advertising those amenities is not a violation of fair housing. For the second one, this ad would not be permitted. So 96% of you were correct there. It is false. It does have a signifier for elderly. So that would be a violation of fair housing. Moving on here. Looking at the Fair Housing Act, it does call out advertising in the Fair Housing Act. It does say that it is unlawful to make, print, or publish, or cause to be made, printed, or published. In regards to protected classes. So it is covered within the Fair Housing Act that it is unlawful to do so, to advertise in a discriminatory way. And then I'm going to turn it over to Liz to talk about some affirmative fair housing marketing.
Okay, multitasking here. Thank you, Bree. Great questions. I'm working on an answer for the senior housing, and I will get back to that in a moment. But again, many federal, state funded entities, if you have insurance from those pools of dollars, if there's assistance dollars tied to your property in Michigan, you have an obligation to create and implement an affirmatively fair housing marketing plan. A little bit of alphabet soup there, AFHMP. MISHDA does require that all the developments that they finance maintain a current and approved marketing plan on site. So again, MISHDA, Michigan State Housing Development Authority. It's essentially a marketing strategy looking to attract buyers and renters of all majority and minority groups, regardless of the protected classes, to these assisted and insured rental projects and sales of those dwellings which are being marketed. There's more information available from HUD on the requirements and the basis of them. And then we developed a fact sheet as well that we will share a little bit from, but I encourage you to check out as well. So it's really making sure, and we can go to the next slide, it's really making sure that people who need to know about these programs and would likely benefit from these programs know about them. For federal housing programs, all applicants for subsidized and unsubsidized multifamily projects, mobile home parks, single-family subdivisions that have 5 or more units, spaces or lots which are funded or insured under certain HUD programs can be subject to these program requirements. So even as the project is being designed and built, they all carry an obligation to create these plans and utilize them in a meaningful way. Again, we have a fact sheet. We also have a training available. We partnered with the Fair Housing Center of Metro Detroit and did an affirmative fair housing marketing training. That video is available under both of our center pages because MISHDA, I'm sorry, can you go back one, Bree? MISHDA did fund us to do that. So just want to highlight applicants specifically may include public housing authorities, housing commissions, nonprofit developers or housing providers, and other HUD program participants. So targeting, identifying populations least eligible to apply. That's where the affirmative stance comes into a play, is looking at, this housing includes units with accessible features. Are we providing a reasonable amount of outreach to make sure that people who would benefit from that housing are finding out about it? Undertaking outreach outlines special measures to attract those populations. You have to line up and develop indicators that will show how your success in the use use of the plan is being measured. And of course, you want to show that staff have training and understand and or have the capacity to comply with this. So all of these are kind of the obligations to think about. So thinking about targeting, outreach, indicators, and staff training. These plans do need to be reviewed at least every 5 years or when your local community development jurisdiction's consolidated plan, often shortened to con plan, is updated. Or when there's significant changes, sorry, Bree, significant changes in the demographics of the project or the local housing market area has changed significantly. So generally it's going to be on a 5-year cycle, but it may not always be that way based on what's happening in the market and in the community. Some mistakes that we've seen, incomplete information, the number of units, the pricing of units, the marketing area is not provided. So it's really not fully fleshed out what the plan is. Other findings would be like insufficient research was not done. Was done. So all ethnic groups were considered least likely to apply. It wasn't really personalized to the target area, the geographic area. There was a failure to advertise in places used by the people who have been deemed least likely to apply. Or there's a lack of follow-up with community contacts to ensure housing opportunities have been advertised. Kind of dropping one letter in the mail is not going to be sufficient to the success of meeting the goals of affirmative fair housing marketing, and certainly probably isn't going to be enough for any plan. And again, those indicators, there were no standards in place to make sure it was an effective marketing plan, or there was a lack of current staff training on fair housing laws. So kind of reverting back now to general best practices across the board. I'll turn it back to you, Bree.
Thanks, Liz. Yeah, so thinking about general best practices on advertising, it's really important just to review all of it with a fair housing lens before you're publishing and posting. Again, describe the property, not the people. Make sure there's nothing within the language that says, this is ideal for. That's often ideal for people demographics is generally what that is followed by. And then advertising under the Fair Housing Act is broadly defined and includes promotional materials, newspapers, internet advertisements, and any verbal statements. So all of that is included under advertising when it comes to fair housing. And then just a good rule of thumb is when in doubt, take it out. Thinking about human models, that is something that we come across a lot. This is kind of a scale of level of risk. So if there are no human models referenced in your advertising, there's really no risk there. Often just you are describing the units, the amenities, the features, the ambiance, the services. There's no indication of preference there or limits. So no discrimination is present. And then as you go down the scale, if 100% of the residents are shown as white, but there are some Black, Latino, or Asian staff. There is showing some selective representation there, and there is definitely increase in fair housing risk there. And then your max amount of risk there increases when all of the residents and the staff are shown as being white. Some good examples here of human model images, and additionally, people with disabilities being shown in the human models is something that also is to be aware of, especially in senior housing. That is something just to be aware of. Are you showing all people of all backgrounds, all abilities, things like that? Some more best practices here is in regards to the equal housing opportunity logo and posters. These things need to be indicated on the property to show that housing is available for everyone under the Fair Housing Act. There are specific requirements for size and location. You can find that through the HUD Equal Opportunity website. I think that link, I believe, does take you there. The posters are no longer printed by HUD, and we talk about this in our 101. So you are able to request those from us. I know some folks did request them in December, and we're going to get those printed out to you. But if you would like those, please email us and let us know that you would like some of those posters and how many. Now moving on to occupancy standards. Occupancy standards are often based upon the local health and safety codes. And it's really important and just a best practice to not really put those limits in advertising. Oftentimes, you can just say, excuse me, a two-bedroom. And then from there, if somebody applies and they don't, um, they max out the occupancy based on local health and safety codes, then that's when you inform them, oh, this is the amount of people in your home, goes outside of the occupancy based on these codes. And it needs to be based on the number of size and the number of bedrooms and sleeping areas, the size of the unit, the physical limitations and structures of the housing, um, age of children, which with caution, which we've talked about in, I believe, in our 101, based on, newborns and things aren't really considered part of the occupancy until their second birthday. So those are things that reasonable occupancy requirements are based on. Um, we have a example here. I'm looking for four mature and responsible people to share a six-bedroom, 3.5 bath, 400 square foot historic home. This would be an illegal or a fair housing risk statement. And another one is two people per bedroom is our corporate policy, no exceptions. Previously, a lot of our homes were built that way, and that's why that standard was kind of the prior standard. But now that our homes are being built very more open concept, bigger, more people are accommodated in the unit. So it's really important to utilize square footage and local state local health and
Health and
safety
safety.
laws. Thank you.
Or property maintenance code, yeah.
Or property maintenance code.
Yeah.
Some other illegal statements that we've seen: parents have to have their own bedroom. Boys and girls cannot share a bedroom by law. Two heartbeats per bedroom per room is Michigan law. If
That
you
is
have
not true, by the way. There
kids,
is no Michigan law that states that. I was going to jump on and just address the two heartbeats if I can
yeah,
really quickly, Bree. That comes from a HUD memo issued by a HUD secretary with the last name Keating. So we call it the Keating memo, and it does reference, kind of the two people per bedroom standard, but that's really a starting point. It's not a hard and fast rule. And Bree, like you said, it really has changed how we build. We have open floor plans, we have loft spaces. Um, a lot of people have um, kind of in-law suites or what they used to mother-in-law suites or rooms that really could be, guest space with partial bath and partial kitchen facility. So these are all things that have been held up as possible defenses and do not hold water in terms of successfully pushing back on a familial status occupancy case.
thank you, Liz. Additional statements that we've seen and are really restrictive when it comes to occupancy. If you have a baby, you have to move to a bigger unit, as mentioned. If a person is pregnant or they have a baby, it's really important to give that person time or give those people time and that's why up until the child's second birthday has kind of been some case law when it comes to occupancy and younger children,
Mhm.
giving them time to get a bigger unit. Um, no more than three persons shall permanently occupy or reside in any two-bedroom unit. No more than four persons in any unit which has been expanded to include a third bedroom without the express prior written of the association. This comes from condo association bylaws.
And they basically rounded down a number instead of going not even two people per bedroom, they rounded down. And so that's really an example of moving that number in a way that's more restrictive for families with children. If you have a three-bedroom with no more than four people, that's just generally not going to be backed up by local property maintenance codes. But it really depends. I mean, in some historical homes in neighborhoods, I've seen teeny tiny bedrooms that really legally only can hold one person, and I've seen large bedrooms that can hold three or four people when we're talking big square footage. So that's why the case by case element is really important. We have a good question about somebody saying our standard just happens to be two people per bedroom, but it is based on local square footage occupancy laws. So that's kind of just a coincidence. And we do really recommend communicating that occupancy standards are based on local law because that's a neutral thing. It's not about who wants to live together and how many people. It's a local property maintenance code standard that you're in compliance with, or a health and safety standard that you're in compliance with, or what, however you want to couch it. It's based on an existing neutral law. And it's not about who or how many people want to live together. So it just is, I think, coincidental. And I probably could guess the age of the property of when it was built, if really it is very consistently two beds, two people per bedroom. That is certainly something that if somebody inquires about that, you can share that you've done the work and it's based on existing law that you do need to be in compliance with. So hopefully that's helpful.
Yeah. Thanks, Liz. And as mentioned, as a best practice, it's really not, don't advertise that way, the two-person per bedroom. It could be that's your internal policy based on
Mhm.
the calculations you've done, and the work you've done on behind the scenes. But advertising that way really can show, can be restrictive and seem restrictive.
hmm And a follow-up question on our second bullet point here. Is there an age limit on boys and girls sharing a room? Like, for example, a boy who is 5 can share a room with a girl that's 3, but a girl that is 16 can't share a room with a boy that is 12. Is there a Michigan law on that? There is not. So really what we're looking at in terms of occupancy is how many people identify as a family or as a household seeking to live together, and how does that line up with the occupancy calculations that you have done or will do? And we'll kind of go through some examples and our kind of process for establishing occupancy, and then I'll circle back. There's a couple of questions that we'll circle back to after we've kind of shared that a little bit more information. So back to you, Bree.
Thanks. And I may have spoiled this one, but we have another
Oh.
poll here. What should someone do in this situation? So, a family of four lives on the property. It's a two-bedroom unit. They've recently had a baby, their third child. The unit is 949 square feet and only holds four people according to local code. Their lease is not up soon. What should they do? Begin paperwork to move them out. If they do not ask for the larger unit, they should not be forced to relocate. It is usually reasonable to give the family at least through the end of their lease and even up to the child's second birthday to vacate the premises or consult local ordinances, the fair housing fact sheets, and guidebooks.
Give a little bit of time here. There's a question in the Q&A that asks, is it Michigan? And I'm sorry, I want to make sure I know if you could add some clarification to that, which portion you're asking about, if it applies to Michigan. But in general, the reasonable occupancy standards are looking at local code across in use across any city, across any county. If there is no occupancy code that exists or property maintenance code that exists at the local level, a lot of folks default to the International Property Maintenance Code. So generally what we're saying is there has to be some work done, regardless of where you are geographically, to figure out what exists at your local level. And again, we'll talk a little bit more about that. But if you have a specific question tied to is it Michigan, please let me know.
Give folks about 20 seconds or so here. And this also should be multiple choice, this poll. So select all that apply. And again, these are anonymous and they're not utilized for grading or anything. We just want some engagement, get you guys thinking about different scenarios. Okay, I'm gonna end the poll here, so get your answers in. Sharing the results here. Many of you got the correct train of thought. The first thing, yeah, if they don't ask for a larger unit, they should not be forced to relocate. And then again, it also is reasonable to give them at least through the end of their lease, and even up until the child's second birthday to vacate the premises. And then also you can consult your local ordinances, your fact sheet, your guidebooks. To make sure that you are following local code or property maintenance code. So the only thing that would be problematic would be beginning the paperwork to make them move out. So thank you all for that. Um, so those are the answers there. Looking at the occupancy guidebook, and I think Liz maybe just mentioned this, we do have this guidebook that helps determine the limits, occupancy limits based on local restrictions. Ours is with the lens of Kent County, and it was made in 2019. So some of that information is subject to change. So make sure that you are verifying which codes are being utilized for occupancy limits. But essentially, the guidebook just walks you through how to determine it. And it's really designed for all those who are offering housing. So, condo associations, landlords, property managers. And it is a step by step. So, we have step one, determine which local unit of government covers the property. Sometimes folks have a Grand Rapids address, but they're actually in Kentwood or Caledonia, things like that. They may, so really verify if there's a more hyper local village or town that your property is actually in. Step two, determine whether or not they have a property maintenance code or other code that limits occupancy. This is often done. There's the code websites that were linked in the beginning of this training that you could utilize, or you could call them up and ask about if they have any occupancy codes. And then reviewing, if they don't, then you would default to the most recent International Property Maintenance Code. And then we review those requirements for relevant information. Then calculate it. We do have a square footage calculator that is based off the International Property Maintenance Code for 20, I think it's on the next slide. So you'll calculate that based on the square footage, and then use that to determine the appropriate occupancy limits. And then make sure you're documenting your process, that you did the work. This is kind of what this tool looks like. Ours is based off the 2018 International Property Maintenance Code. So just ensure that those numbers are still meeting yours. If they do, you can utilize this and it'll pop it out how many people. And it goes through bedroom areas, sleeping areas, living rooms, dining rooms, things like that. And then really what should be done, make sure that your properties, your programs are familiar with the occupancy standards within your locality. Housing providers only need to know the number of people that will occupy the unit. They should not be more restrictive than any other codes. And then, as Liz mentioned, there is the Keating memo that does have some information on occupancy that you can reference there. And then we also have additional occupancy resources on our website that you can filter for.
Okay,
Now,
can we take a couple questions
yep.
now that, yeah, thank you. So after a baby is two, how would you handle that if they go over the people per unit? And I think that's one where you kind of have to do an individualized assessment. Is the lease close to expiration? Is it month to month? And, so you can gather that information and do an assessment and reach out to your local fair housing center to kind of figure out what's the best next step in terms of what would be an equitable approach. But I think case by case is probably a good standard to gather. If they have a year left on the lease and the child is well over the age of two, then and you've got good code information that would be violation. You want to kind of figure out, like Bree said, just some accommodations to help with that transition. But you don't want to be punitive. And kind of a follow-up to that is if you don't have an open bigger unit or a bigger unit on your property, I mean, ideally, for great tenants, if you have the option to transfer or you have the next bedroom size up that they would want to look for, that may be an opportunity to get them on a waiting list or find out if that's something that they're interested in. But that's also an element that needs to be considered too. Question on, is it MISHDA's rule that there has to be 2 heartbeats per bedroom for PBV units? I'm going to guess that's project-based voucher units. Um, I don't know what MISHDA's rule would be that would be separate from project or specific for project-based. Wow, no wonder we say PBV. That's also hard to say. So that's something, are you permanent supportive housing? We might need a little more information and kind of do a correspondence via email on that one, if you don't mind. I think that would be helpful. Another question, if a bigger family is moving into a 1 bedroom unit, say 6 people, is it possible to suggest them to move to a bigger unit, or would that be implying that they can't afford the bigger unit? So that would have to be a very large 1 bedroom unit, which I'm not saying it doesn't exist. We build very differently. But essentially, if you do have an inquiry, let's say you've done the math and you know that let's use a 3 bedroom. Your 3 bedroom holds 5 people because one of the bedrooms is very small. So we've got a 3 bedroom that holds 5 people that's been verified under reasonable local occupancy standards, and you have a family of 7 who applies. They don't qualify for that unit because it would put you in violation of local law. Um, it's striking a balance. We don't want overcrowding. We don't want people injured this time of year. So many house fires, things like that. It's striking a balance with those health and safety concerns and allowing the reasonable number of people to be there. And we
Yeah.
actually did just read a case, right, Bree, that you found that was really a landlord aggressively harassing a family to move up into the next size that she did offer. But it was like daily harassment, even while the parent was in both parents were in the hospital and the woman was giving birth to the child, they were still getting messaged. I mean, it was, and HUD has charged that case. And part of it was their assessment was they couldn't afford what she wanted to charge them. So we're going to keep an eye on that one, and maybe we'll share that case when we get a resolution on it. But a lot of people are going to look to maybe minimize their rent costs, but it has to be done in compliance with property maintenance code and striking that balance.
And that's how you would communicate that out, is that it's against how, local occupancy codes, safety codes, explaining that. And again, like Liz had mentioned, like falling back on that code, that law that says, I can't allow you that many people to be in this size of unit. Um, but I understand it can be a delicate situation if the people are trying to do it for affordability.
Yeah. So, and then very quickly going back to source of income protections, um, the source of income protection goes into effect February 13. However, the mandate to accept vouchers will go into effect April 2, 2026. So actually, Michelle, it's April 2, 2025 when the source of income protections become law in Michigan. April 2, 2025. It is not February. That would have been February of 2024 when sexual orientation, gender identity protections went into place. So just to clarify, the Michigan source of income protections go into effect based on what we're hearing from the state and finding from the legislature, April 2 of this year, 2025.
Thank you for that clarification.
Yep. And then one more quick question. What happens if it's a split family, stepkids, does age matter on kids to share a room? So there are no, unless there's supportive housing with like services related to maybe mental health or something very specific which is just generally not going to happen for anybody on the call. There are no age restrictions, and it's not up to us who sleeps where, how they're related, how old they are. It's best simply to know how many people seek to live together and do they qualify based on your occupancy standard? All of those details are really unnecessary, especially if all you're doing is providing housing and there are no supportive services that would have any other recommendations. So there are no age and child requirements in terms of who can sleep where and with whom in bedroom spaces. So hopefully that clarifies that. Thanks, Bree.
Thanks, Liz. Good questions, everyone.
Yeah, really good.
We enjoy questions, so please keep them coming. And as if we can't get to them, please email us with with that
Follow
question
up.
if we don't,
Yeah.
yeah, if we don't get to it. We have another poll here. I know everyone is loving these polls. I am. Um, so
We always get positive reviews on the quiz questions.
these are true and false. The first one, as long as something is part of a written policy in use at a property, it can't violate fair housing laws. True or false? The second one here, rental unit records should be kept for at least 3 years. True or false? Give folks a minute here to answer. Probably a minute and a half. Okay, looks like got a lot of folks chiming in. I'll give about 10 more seconds here on these true and false questions. All right. Share the results here. For the first one, 92% of you are correct. That is false. Just because something is a written in policy at your property doesn't mean that it can't violate fair housing laws. We often do see that written policies do. That is where we find a lot of violations are in within written policies, and that is something that we can review before you put a policy in place. If you're not sure, we can review your policy, a written policy, to see if there's any fair housing, a final written policy, if there's any fair housing risk in your policy. For the second one, rental units, rent get records should be kept for at least 3 years. 82% of you are correct there. That is true, as that is the statute of limitations. So looking at best practices here, use existing or develop an implement written objective policies to establish standard protocols and promote consistent and equal treatment. It's often really important to regularly review any written policies for compliance and ensure that that everyone understands them and that they are practiced consistently as well. So just really making sure that they're objectively consistent and provide equal treatment and that they're reviewed as, laws are changing as we've talked about. So maybe it might be a good time to review any written policies if you do have source of income called out, as just an example. Consistency and choice, making sure all staff, residents, and applicants are equally aware of the criteria for applications. If there's any rebates, specials, again, making sure consistency, make sure you're voicing that to everyone and that everyone knows about it, ensuring housing choice, that there shouldn't be choices made on behalf of the housing provider on which a unit or property meets someone's needs. That really should be up to the people. We often see those choices being made by housing providers for people with disabilities or families with children, and maybe coming out of a good place that you're like, oh, there's a balcony there. this family with a 3-year-old shouldn't live there. As that's really kind of you to think about that family in that regard. That's really up to them to decide if they want that unit with the balcony or with a person with disability, maybe assuming that they can't utilize stairs and not offering them any units with stairs. All of those things need to be offered to people regardless of a protected class. Right? And they should be able to choose what best fits for themselves in their life. Thinking about applications for best practices, again, making sure that all of your policies are in accordance with laws. Do they some things to be asking yourself? Do they discriminate against anyone based on a protected class? Are they applied differently to persons that may fall within different protected classes? Are they consistently and evenly applied across the board? Are you consistent with information about vacancies, wait lists, qualifications, rates, security deposits, any reference checks, credit checks, employment checks, rebates? Are all of those being broadcasted and vocalized to everyone across the board? And then thinking about what information is necessary at what point during the application process. Applications should be collecting relevant information to determine if they qualify for the housing. Ensure that no unlawful questions are being asked. Review the information being collected but not used. So if you're collecting information on the application but you're not really using it, that might be a good thing to pull out, especially if it's in regards to a protected class. It shows the burden then shifts to show how information is collected, did it or did it not influence the housing decision making. And then again, distinguish between what information is necessary at the application point, or maybe it's after they've been approved. If you are just a property that likes to send out birthday cards or birthday notes or things, want to promote things that are different based on their interests, that might be a good thing to ask after they've been approved with some, make sure you're looking at it with risk, but making sure that's not asked at the beginning of the application process because it could be shown that maybe that information was utilized to decide if this person can live there. It's a good thing to keep the list of protected classes handy, so you're referring to that list. How would an applicant or resident treatment vary by protected class based on your application or based on whatever criteria you have? Is there adverse treatment or unintentional barriers? Thinking about who's left out. Could you defend any findings as non-discriminatory? Is there evidence? So these are things that we even question when folks are asking us questions and best practice questions, thinking about who was left out, looking at that protected class list to say, okay, would this affect somebody based on national origin? Would this affect somebody based on disability or religion? Things like that. We have a case here out of New York where a housing authority was providing a questionnaire, but it also conducted an in-home examination to determine if the applicant could live independently. Their client was denied housing because the authority did go through this examination and questionnaire, and they determined that, because this person, the applicant, could not walk without a walker. They had to use adult diapers. They needed assistance, that they could not live independently. The court did rule that these requirements were unlawful based on disability. So if you are just a housing provider with no supportive services, there is no reason to be conducting an in-home examination or questionnaire to see if people can live independently. And then thinking about the process all the way through, accept all applications, inquiries for waitlist if feasible, date and time stamp for first come, first serve model. Make sure you're looking at the credit check, income references. Think about legitimate business reasons for the basis of any of your decisions. Think about your list of protected classes. Make sure you're being consistent. And then if they arise, make sure the process is acceptable for reasonable accommodation and modification requests, which transitioned us to disability. Um, so, disability is defined under fair housing as a physical or mental impairment that limits a major life activity, having a record of such impairment, or being regarded as having such an impairment. And major life activities are really broad, and they are anything that affects physical, mental, or social activities, including sleeping, walking, bathing, eating, driving, hearing, seeing. There are two ways for people with disabilities to have equal access and enjoyment of their home through reasonable modifications and reasonable accommodations. We have the HUD DOJ joint statements linked here in our PowerPoint. This is a really great unit. It does a lot of like frequently asked questions and kind of gets in the nitty-gritty of the two. So definitely check out those documents when it comes to modifications and, and accommodations, as there's a lot of information in there. A reasonable modification is the structural or physical change to a structure. Examples are ramps, grab bars for the bathroom, things like that. There's the little X there. That would not be accessible as there is stairs there. But then if you see on the lower, a ramp right there or some grab bars. The Fair Housing Act requires individuals, corporations, associations, and others involved in housing to allow for modifications. This includes property managers, housing managers, condo associations, and homeowner associations. This picture here was a case from a homeowners a condo association where a person was requesting a zero-step entry. They were denied that because they wanted to keep the consistency among the homes, and they were worried that it would look ugly and not, and that's a lot of pushback that we get from condo associations and homeowner associations for allowing modifications, but they are meant to be allowed. And then afterwards, as you can see there, it looks really nice for that zero-step entry. Section 504 kind of changes how we think of reasonable modifications. So if you receive federal financial assistance, there's some lists there, USDA, rural housing, HUD subsidized, things like that. If a person needs those structural changes or those reasonable modifications, it's not considered that anymore, and it's considered a reasonable accommodation. And thus it must be paid by the housing provider unless it would be an undue financial or administrative burden or a fundamental alteration, sorry, of the program, and they cannot accommodate the individual by any other means. So, for reasonable modifications, oftentimes in the private market, the cost does fall onto the tenant, but in federal financed housing, it falls on the housing provider. A case here from a local or from another fair housing center here in Michigan, where a gentleman and his wife were moving here from Kentucky to be near their family, as Mr. Davenport was having some health concerns. They were looking for ground floor apartments that would help with the caretaker, a local caretaker. It was close to the caretaker. As soon as they found them, they took action. They put down a deposit and they asked for permission to install structurally sound grab bars in the shower. And they were even saying, they kind of did it there at the forefront. We'll pay for it. We need this. Here's our deposit. But this is what we need for Mr. Davenport and his disability. The apartment complex refused this request, insisting that they only allow suction cup grab bars. However, the family pushed back because that would be dangerous for him and his specific disability and his disability related needs. However, the complex was really concerned about leakage. However, the family tried to provide more information on this, and the complex really just stopped communicating and then rented out um, to individuals who paid their deposits after the Davenports did. This did go as a federal lawsuit, and was filed, that they refused his reasonable modification request, and that the suction grab bars were insufficient for his needs. The apartment complex did deny liability, and but they were able to reach a settlement that included placing an anti-discrimination policy on their website, fair housing training, and a disability rights notice on the application. However, the family did have to move to an apartment that was way less accessible, more expensive, and farther away from the caretaker. So that last line, just thinking about how folks are impacted by denying them choice or denying them the reasonable modifications or accommodations, really what happens to them. In this instance, it was the least probably least likely apartment that they would have moved into, but that's kind of what this case led to. So thinking about what types of steps for processing modifications, thinking about who will use it. Will there be any issues when it comes to code compliance? Do you need documentation or plans? Who pays for it? And as I mentioned, private housing, generally the tenant, federally funded housing provider pays, and then thinking about what happens when the tenant moves out. So it's important to, when getting a reasonable modification request, to be thinking about these questions, but when going through the process of approving it. And then, sorry, this goes into the next spot, but all information requires homework. That is something that we can help with, and we have a guidebook that also helps with this process that is linked there. Then moving on to reasonable accommodations. These are changes in rules and policies or procedures that are needed for a person to have equal access and enjoyment of their housing. Some examples: an overnight caregiver despite an overnight guest rule, allowing an assistance animal despite no pets policy, uh, assigning a designated parking space despite first come, first served parking policy, accepting rent based upon the arrival of a disability without charging late fees, releasing from the lease penalty free if the housing no longer meets the needs of the person, and then transferring to a different floor or unit based on the disability related needs. A case here out of Texas. This case was with the Housing Authority of Dallas, Texas, and they were required to pay $500,000 to a former public housing tenant. This tenant requested a transfer to a ground floor after a car accident, and she was no longer able to climb the stairs. She was forced to crawl up and down the stairs to access or leave her home, causing her physical pain, injury, and humiliation. They refused to accept her rental payments and then eventually evicted her. The tenant then became homeless. This is a pretty egregious reasonable accommodation denial. HUD found that the housing authority failed to grant the accommodation for the transfer and that they retaliated against the tenant. The housing DHA denied wrongdoing in their agreement, and they will vacate all judgments it's obtained against her and clear any debts they allege she owed. They have to pay a civil penalty of over $10,000 to HUD. Overhaul is its reasonable accommodation policy and pre-eviction grievance hearing procedures, and then they have to establish an effective communication policy for individuals with disabilities. Thinking about what steps or what questions you have to think about when processing a reasonable accommodation. What does the existing policy or rule say? What is the standard, and how is this request different from our normal standard procedure? Do I need documentation? Do they have a visible disability? Because if they have a visible disability, documentation may not be needed. If you can see why, if they're in a wheelchair, you don't need documentation for the ramp that they are requesting. When or how does the policy, how is it changed? And then again, this is something that would require homework, and that's something I guess, again, we can help with.
I have a couple of quick questions on accommodations, if that's okay, Bree, because assistance animals are coming up next. And I'm already getting questions about those. So let us answer accommodations and modifications real quick, and then Bree will get through assistance animals and we'll circle back to those. Does this cover homes purchased by the resident but are on rented land? So these disability-based protections for accommodations and modifications are very broad. The disability protections not only include the person with the disability, but persons associated with the person with the disability. So generally, it's also, I think it's safe to assume that there's going to be some coverage. It depends on what the request is being made, though. If I'm renting a lot and I have my home on the lot, but I need a ramp, that's going to be touching both pieces, both the land that it's on and my door. So these are all interactive and kind of collaborative processes where people need to work together to meet the needs. But essentially, kind of based on those real general facts, fair housing laws are going to apply for modifications there. And then a quick clarification on Mr. Davenport's case. Did he lose the case or did the complex comply with his request? Well, they stopped talking to him, so he moved in somewhere else into an entirely different property that did not meet his needs. So that feels like a loss. There was a settlement, but he did not end up getting his first choice of housing. He didn't move into that complex, so the complex had to kind of mediate, but he needed to move on, as is often the case. When people are looking for a place to live and experience discrimination, that discrimination often pushes them into housing that doesn't meet their needs. And he was not, in this instance, able to get housing of his choice. So hopefully that helped. And the grab bars the complex wanted were definitely not what he asked for and what he needed. And as you say, weren't safe. So.
Yeah, and there may have not been, I can't remember on that case, there may have not been a disclosure of what the settlement was. Sometimes they
We
are,
didn't get details.
yeah.
Yeah, other than the complex had to um, put the notice on their website and, update their policies and get training, but no real details in terms of hopefully they know the right kind of steps to take now.
Great. So hopefully, going into this section, folks, we can answer some of your questions. I do have a poll here that I'm going to launch. I'm going to try to do it fairly quickly, as I know this gets a lot of questions. But true or false, when somebody with a disability asks for an accommodation for an assistance animal, you can always ask for proof of disability. Number two, you cannot require that an assistance animal have an official license or certification under the Fair Housing Act.
We've got some quick responses on the lightning fast reflexes with folks filling these in. And some differences of opinion, which is why we're glad you're with us today and taking the time to dive a little bit deeper than we did in the 101 to these kind of hot topics or areas of fair housing that have complexities and nuances, as you've heard us kind of talk through and think about together.
Yeah, I'll do about 30 seconds here for these questions. You guys are really quick on these, so. Alrighty. Gonna end the poll here. Get your last minutes answers in. All right. Share the results here. As you can see, there was some of these were pretty close. So when somebody with a disability asks for an accommodation for an assistance animal, you can always ask for proof of a disability. That is false. It really is dependent if the disability is visible or not. If you can see that the person has a disability, then you may not need that documentation. So it's not an always, it's a sometimes answer. You cannot require that an assistance animal have an official license or certification under the Fair Housing Act. This one was pretty split, but the answer is true. There is no official licensure or certification, and it says assistance animal. So as we dive into this a little bit more, this kind of transitions me into the next question or the next section here. There are two types of um, assistance animals. The key word was that there was an assistance animal. So there's service animals, which often have those certifications or identification. But the second bucket under assistance animals are support animals. These are trained or untrained animals that do work, perform tasks, provide assistance, or provide therapeutic emotional support. Assistance animals are not required to have those certifications because it may be an untrained animal. The 2020 guidance does go through a series of questions of a yes, no, and it kind of starts off with, is this animal a dog? And then you kind of go from there. So it really starts with that trained service animal piece, which would be um, that has maybe a certification, and then it transitions to support animals, which most people have a lot of questions on. It incorporates information that you may already have about the person and their disability related needs. So that's something that you need to be thinking of. Do you already know that they are a person with a disability because they receive SSDI, or they've mentioned it before, things like that. Sorry there. It covers that any domesticated animals, dogs, cats, birds, rabbits, that are traditionally kept in the home for pleasure rather than commercial purposes, are permitted. Reptiles, other than turtles, barnyard animals, monkeys, kangaroos, and other non-domesticated animals are not considered household animals, and these would be kind of the unique animal, and they would need to just demonstrate a disability-related need for that animal. So if it's a domesticated animal that's traditionally kept in the home, no further information is really needed on why that animal is specifically necessary. Whereas if you had a monkey, you would need to really show that, okay, this monkey opens up my medication, and so that is why I need them. But if they were just requesting a monkey because they provide the therapeutic support, they would have to say how that is different than a domesticated animal. No fees, no pet rules, no limits on breeds or sizes are to be permitted for service animals or assistance animals, support animals. You may refuse a reasonable accommodation if the animal poses a threat to the people or property and cannot be eliminated or reduced by different actions taken, by the person to maintain control of the animal. It is the tenant's responsibility to feed, maintain, care, and control of the animal, and we do have a sample um, sample assistance animal policy that kind of you can provide within your lease when somebody has an assistance animal that they can agree to. That kind of goes through that this person is still responsible to maintain and care, feed, control the animal. Disclosure of details about the diagnosis or severity of the disability, any medical records or examinations cannot be required. Essentially, the information that you need as a housing provider is that is this a person with a disability, and do they have a disability related need for the animal, and what is the nexus between them? Must discuss or offer an alternative accommodation if the original request is denied. And that's a standard for both accommodations and modifications. If you cannot meet those, there has to be offered an alternative to those requests. The guidance also covers that the tenant and the housing provider must engage in a good faith dialogue. This is often called the interactive process. The housing provider may not insist on specific types of evidence if the information provided is known to the housing provider and meets the requirements of the guidance. Housing providers uh, may not require a healthcare professional to use a specific form, including HUD's document. You cannot require a notarized statement to be made or that the healthcare professional make statements under a penalty of perjury. You can recommend, and as we have in our guidance and in our stuff, we have sample letters and things. Those are, again, just samples and things for people to that kind of get them a start, but it cannot be required. Some issues that we see when it comes to documentation requiring use of special forms, time limits, using subjective language about a disability, assuming a person is trying to avoid pet rules or deposits, requesting for more information that is needed, including number of treatments, other treatments attempted, um, asking for agreement to additional charges on the front end. You are, as a housing provider, you are allowed to, if your standard procedure is to receive a security deposit and then assess for damages at the end, that is something that you can still do, but you cannot charge anything on the forefront. And then another issue we've seen is asking healthcare professionals about their willingness to testify in court or other proceedings. These things are not allowed. Thinking about inadequate or no documentation, it's we often will say to educate the requester and invite them to open up to provide further information. There is a second section in the assistance animal notice that you can provide to tenants or applicants to kind of inform them on what you are looking for and what the guidance says. We are always about being transparent for both sides. So we do have a resource guide on assistance animals that's both for tenants and for housing providers. It's written for both. Because it's just relaying that information that's in that notice. It is a lengthy document, the HUD notice, but it is really a good thing to read through and understand as it provides a lot of nitty-gritty information on assistance animals. We also have a RARM guidebook for housing consumers. We have one for housing providers, but they're written with different lenses, but it's the same information. You can also refer them to us or our website. And then thinking about your determination, it really is made on a case-by-case basis, and understanding the facts with the information you have. And then again, if you deny a request, you have to offer an alternative. Some best practices, it may be helpful to consistently maintain lists of reasonable accommodation requests, make a determination within 10 days of receiving documentation. Remember, assistance animals are not pets. They are an assistance animal, an assistive device for a person with a disability. Conditions and restrictions that housing providers apply to pets may not be applied to assistance animals. As I noted, we have an assistance animal policy that is different than a pet policy. It's really important to have those two things different. Assistance animals are not subject to pet policies. So that is really important to make sure you're having that difference. You can charge for damages at the end if that is your usual practice. And then again, our resource guide is linked here. The resource guide is meant for use for anyone. It can be for a housing provider and advocate. There is a sample support letter and that sample assistance animal policy in there. The sample assistance animal policy is something we really highly recommend folks adopting because it addresses behavior and care, a lot of concerns that people have when they are no pet property maybe, or they have a pet property, but they have a pet policy and they want to address those things. It can help with accountability and education. It gives that you have expectations of your tenant and they have to uphold those. It documents you accept assistance animals and that you distinguish they're different from pets. It does customizable for your name, and it's recommended that everyone is signed and every copy is given to all parties that are signing it. This case comes out of Minnesota. I think that's what MN stands for. Um, Minnesota. And this was a case charged by HUD, where they charged the owner of the apartment complex and the landlord with violating the Fair Housing Act for allowing or for refusing, sorry, a woman with a mental health disability to live with her assistance animal. They The landlord denied the request for the assistance animal and even rescinded the offer of the lease, even though the applicant provided their disability-related need. It was supported with the request, a letter from a therapist, and all that information was provided to the landlord when they were getting the request. They even included information from HUD on the right to a reasonable accommodation, and it was still denied. And the landlord told her to look elsewhere. She also did not return her security deposit. Her response to her disclosure of her disability need was that she suggested to get rid of the cat or rehome it she adopted a until he adopted, sorry, a pet policy. Upon receiving the verification letter and HUD info, the landlord emailed back, "There are other places. Don't worry, I can refund your deposit." So again, that continuous denial, even after receiving more information that this was the information was appropriate. The application was then forced to seek live to another place to live under a tight deadline. The complainant suffered actual damages, not just limited to physical and emotional distress, inconvenience, frustration, and loss of housing opportunity.
Bree, taking a look at the time here, there's a few questions I want to get to. I'm trying to keep up with responding, but it's easier to answer some of these verbally, and then we'll just take a quick look at processing requests as we look to wrap up here. Can you ask on an application if they have an ADA or ESA animal? We really discourage any type of questions that are not used to assess whether somebody can afford the apartment and is outside of what you need to assess creditworthiness, objective criteria not related to protected classes on an application. It's just a best practice to keep that separate. You could be charged with making a decision based on the fact that they said, yes, I do have an assistance animal. If they got denied for any reason, that opens the door to fair housing risk and them filing a complaint. You would have to prove that you didn't use the answer to that question to make the determination. So we really encourage that not to be included on an application. Pet-free community rules are fine. And yes, you do have to consider accommodations for both service animals and support animals. You are subject to the Fair Housing Act, so you do have to accommodate both types of animals, not just service animals, but also emotional support animals. You cannot limit yourself to just one category of animal. In terms of limiting the number of pets, you can limit the number of pets. Assistance animals and support animals are different. There's a homework that needs to be done there. If they say they have 4 dogs that are all support or assistance animals, then you have to do a case-by-case evaluation. You have to look at, do they have documentation showing that multiple animals are necessary? Is there any local law that might prohibit that number of animals residing at that property within city limits? So that's a situation where there's homework that needs to be done. But you can verify that there is a need for multiple animals or ask for verification from a third party. Annual renewals, if the verification provided has an annual renewal date, I would approach that with caution in terms of, do you really need to reassess the request or not? It's something that we generally discourage because it can be very time consuming to annually re-renew, and that you would be requesting additional disability related information. You can request information to show that the animal is a assistance animal if you can't observe the disability or the disability related need. Please see our sample assistance animal policy about addressing picking up or setting policies about cleaning up after the animal. We recommend having that sample assistance animal policy adopted so that you can help manage the presence of the animal, including keeping animals quiet, honoring quiet hours, making sure waste is removed, etc. Getting a lot of letters from healthcare providers saying that research is beneficial for them to have a pet. um, the letters doesn't say it's a requirement to accommodate the resident's disability. You can't require someone to fill out a form. You can offer a form. And generally, when you get inadequate information, as Bree said, we encourage you to educate the requester, to provide the information that answers the two questions that housing providers can ask. Those are listed in the 2020 HUD guidance. For online certificates and ongoing treatment, there's a section on internet documentation that HUD addresses kind of that balance of if they're selling verification and there's no ongoing treatment. We really, again, recommend you educate the person, give them the opportunity to provide documentation that answers the questions you're allowed to ask. It's again a case by case assessment. We don't want to see abuse either. So really rely on that documentation. Insurance companies should not have breed limits for any sort of disability related need or animal. We understand those sometimes do pop up, and we've tried to work with the insurance regulations groups to educate them that they are subject to federal laws, including disabilities under ADA and fair housing laws. So the HUD guidance is very clear. You cannot have a breed limit or preference under assistance animals. With guests having animals on the properties, can we or can we not require them to verify the same we do if they're claiming the animal is visiting? We've asked the Michigan Department of Civil Rights about the rights of visitors with assistance animals, and they say they are people who do need to be accommodated. If you can't observe the need, I think that would be something that could be evaluated. Okay, we have 3 minutes left, and I'm briefly just going to talk about the interactive process. I think we've really talked a lot about this. It really is do your homework, do a case-by-case assessment. If you have no disability-related information, you can ask limited questions. Please acknowledge that not every disability is visible. Next slide. We encourage you not to ask for any disability-related information unless a request has been made for a disability-based accommodation or modification. Your first step is what information you need, if any. And again, if you don't have any disability-related information, you can ask some limited questions here. We have step-by-step guidebooks for both you and your tenants and applicants to follow. These are available on our website. We have sample response forms. Here's a quick screenshot. We literally walk through, yes, we're going to approve. No, we need more information, or we are going to offer you an alternative, or we're going to deny your request. And it's all based off of HUD and Department of Justice joint statement guidance. We really encourage you to document everything, keep information confidential, and really listen to the person with the disability because they do have the most accurate knowledge about the functional limitations they experience. And again, case by case basis. We have tons of resources and links all throughout the handouts. I hope all of you did receive them. If there is a requirement, quick question in the Q&A for licensing and vaccinations of assistance animals, if there's a state or city law that requires licensing or vaccination of that type of animal, you can ask for it as long as it's required by an, kind of outside existing neutral entity. Good question. Tons of links here for different MSHDA pages. We are happy if you follow up with us to help kind of get into a little bit of research for some of you who raised some good questions that we didn't have information on at our fingertips. Visit our website. Our resource page is incredible. You can filter by protected class. You can filter by topic. You can filter by language. You can search by terms. That resource page is phenomenal. So please use it or feel free to reach out to us. Now is time for the link please click on this link in the chat to fill this completely out. Every person must individually complete this so that you can record your attendance and give us the information about where you would like the certificate, what name you would like listed, what address. So please take a few moments and fill it out completely with accurate information. Check for typos because we get things returned in the mail, and I know that can be frustrating. Thank you so much for being with us. Please, we'll stay on to make sure you can click this link and keep an eye out for a couple other questions. But thank you all so much for joining us, and we'll conclude the recording of the session, I think, if we haven't already.